Okay, good morning, everyone. Thanks again for joining us in our ongoing series of videos on current U.S. immigration news. In late spring of this year, the Trump administration issued a set of proposed rules to dramatically alter how our asylum laws are implemented. They are draconian, drastic, and extremely destructive. The public comment period ended yesterday. Immigration attorney and asylum law expert Paul O'Dwyer, whose practices in New York City, submitted his extensive and detailed comments to the US government right before the deadline. Today, I have the pleasure of having Paul here with us during his lunch hour to take a deep dive into what some of the proposed changes are and how, if they're enacted, they would affect asylum seekers in the US. Good morning, Paul. Thank you so much for being here.
Thank you for having me.
Yeah, so you sent me this long, extensive document just listing all the comments you made. So I'm just going to follow that, if I may. And before we start going through that, I mean, what do you think? What is the government trying to do by making these proposed rules?
Well, I mean, it's not a secret that the government's goal here, the goal like throughout the last couple of years of the administration, has been to essentially make the asylum process as difficult and as unworkable as possible. So under these regulations, really nobody would be eligible to even apply for asylum. And the very few people who managed to pass the initial hurdles of being able to file an asylum application would not be eligible to have it granted. So essentially, these regulations would completely do away with the notion of asylum as we know it.
So do they affect people that apply for asylum at the border, or do they apply to people who come into the country and then apply for asylum?
They affect everybody. Whether they apply for asylum at the border or whether they have come into the country. So, and that's the first couple of comments I made was with regard to the procedures that affect people at the border. And that's what's known as the credible fear and reasonable fear screening process. So when people arrive in the country, when people present themselves at the border and say that they want to apply for asylum, they have an initial screening interview with an asylum officer to determine whether or not there's a reasonable possibility that they would be eligible for asylum rather than having them deported. And that's traditionally been a low threshold in order to ensure that people who may be eligible for asylum are not deported. So it's inevitable that a significant number of people who are not eligible for asylum who ultimately are not eligible for asylum, ultimately manage to pass that test, because that's the way it's designed to make sure that people who are bona fide refugees don't get deported back to countries where they will be persecuted and killed. And so what this proposed rule does is I mean, some of it I think does not really make a huge difference. It's just very impractical and not authorized by statute, such as proposing that there's a different type of removal proceeding for people who have been found to have a credible fear. I mean, I'm not sure what much of a practical difference that makes, but certainly there's no statutory authority for it. The Immigration Act prescribes exactly how removal proceedings before immigration judges will be conducted, and there's no authority for the agency to then decide to come up with another one on top of what the procedure that Congress has prescribed to happen. They can provide regulations explaining how that congressionally prescribed procedure will happen, but they can't come up with another one. More importantly, I think, is that they make it much more difficult for anybody to pass a credible fear test. And some of that, essentially what they say is that the asylum officers will consider the law which is the least favorable to the asylum applicant in deciding whether or not there's a possibility that they will be eligible for asylum. And in understanding how that works, it's important to know that in US asylum law, So there are several different circuit courts of appeals, and the law on asylum can vary from one circuit to another. So for instance, if you're in New York within the jurisdiction of the Second Circuit, the law on asylum can be more liberal, more progressive, whatever, than, let's say, if you are in the 11th Circuit or the 5th Circuit, which is in Texas. And typically, and so because nobody knows at the asylum screening stage whereabouts the person is going to end up, the asylum officers typically do not decide to determine somebody ineligible for asylum simply because there is one circuit in the country which has unfavorable law, and apply that to the person's case. Under this proposed rule, that the asylum officers are free to apply the most negative precedent from any circuit to the person's case to find it that it's unwilling. The most important thing, however, is that in asylum, there are things called the eligibility bars, which is things that will make you not eligible for asylum. And those are if you have been firmly resettled in another country, if you could relocate within your own country, if you have been convicted of a particularly serious crime, if you have been convicted of an aggravated felony, all these things. And those are very complicated questions as to whether or not those apply to somebody. They're very fact intensive, they're very detailed, they require very specific evidence, and they are legally complicated. Those issues regularly end up being argued before the courts of appeals and sometimes before the Supreme Court as to what types of crimes make you ineligible for immigration benefits. And so what this regulation proposed, and so because of that, even if an asylum officer believes that somebody may be subject to an eligibility bar, they don't make that determination. They will make it on the notice where they refer to saying that this person has passed the threshold. He may or she may be subject to an eligibility bar, but if not, they would be eligible for asylum. And then the immigration judge makes that determination. These regulations would have the screening officers make that determination. And as I said, those are things that, so people doing those interviews are usually, they've been in the US maybe 1 or 2 days, they're in detention, they have no belongings, they have no paperwork, they have no lawyers, they have nothing. And so to require those people to be able to make detailed legal arguments backed up by documentary evidence relating to their eligibility for asylum just really is counterintuitive, and it's contrary to what the purpose of the screening process was supposed to be.
Right. So right now, I mean, just to key in on what you just said, somebody comes through San Isidro and presents himself to the federal government seeking asylum. Mm-hmm. And then they're put in detention, and an asylum officer then is supposed to conduct a credible fear interview. If they pass the credible fear interview, they are placed in removal proceedings, and then they go before an immigration judge. And the case is heard often for months, perhaps hours at every single hearing, yes, and maybe several hours for evidence to be submitted by counsel and by the government, and ultimately the immigration judge makes that decision. So the proposed rules is, and before I move forward, that person at San Isidro is subject to the Ninth Circuit law.
Yes.
Right. So the proposed rules remove the Ninth Circuit, right? Any circuit that is least favorable can be, the rules can be applied to that individual.
Yes.
Also, the individual at the border, like you said, in detention and under extreme stress and perhaps hunger and perhaps illness, has to present all of this counter argument intelligently to the asylum officer, and I would imagine in less than 30 minutes.
Yeah, like let's say with between 30 minutes and an hour.
Wow. Okay.
And I mean, just by way of example, one of the things that they would be required to do is, let's say somebody transits through Mexico, in addition to all of the other presidential proclamations and asylum bans relating to transiting through Mexico, if you have, let's say, somebody from Guatemala who came through Mexico, they would be required to prove to the asylum officer what immigration benefits were available to them in Mexico, whether or not they would have been eligible for indefinitely renewable non-permanent residence in Mexico, whether or not that would have been feasible, basically to require them to provide a treatise on Mexican immigration law to a border official. In the same way as, like, let's say somebody from Iraq who left Iraq and then went to Germany and stayed in Germany for a month and then came here seeking asylum from Iraq, they would be required to prove why it was, whether or not that they were eligible for immigration benefits in Germany, and what type of immigration benefits they would have been eligible for, and whether it was permanent or non-permanent. And people are just, people are like arriving when they're fleeing someplace, they're simply not in a position to do that.
Right. And in the process, they may have had their children separated from them, put in cages, different cages. I mean, all of these situations, right? Extreme stress, and they need to come up within minutes to argue for to essentially save their lives.
Yeah.
So what else, Paul? This is terrible. What's another terrible thing that happened?
So the other thing, so they've also made two other changes. So they've made changes to when people are applying affirmatively for asylum. That means people who are filing asylum applications, not at the border. But let's say somebody is physically in the country and wants to apply for asylum. So there have been changes to the manner in which those applications are initially adjudicated, which I guess more procedural changes. And then there's changes to the substantive law governing asylum itself. So with regard to the filing of asylum applications, a huge change. Many people apply for asylum on their own. And because of and so when they file the asylum application, they file just the application form itself. Because that's all that's required, is that you simply file the application form itself. And then when the case is ready for hearing, or some weeks before the case is ready for hearing, you submit all of your supporting documentation. And that's traditionally been the way it's done, simply because it's the way it's been required. And also because, given that there can often be years between when you file an application and when you come for a hearing, that it is counterproductive to file all of your supporting documentation with an application without any idea of when it's going to be adjudicated. And so then when it comes up for re-adjudication, you have to submit updated information all over again. So it's much more efficient for the asylum applicant and for the person hearing the asylum case to get all of the documentation at one time, right? Rather than some here, some there, some here, some there, constantly updated. What this regulation would allow is for immigration judges to, what they call pretermit, which is basically to terminate and deny an asylum application before a hearing on the basis.
So when you say before a hearing, I just want to clarify. So, when people apply for asylum, like you said, initially they have what's called a master calendar. That's when you basically go tell the judge who you are, where you're from, and what you want to do.
Yeah.
And then the judge sets another hearing, which is the individual hearing, and that's when you litigate the matter, right?
Yeah.
So what you're saying is that at the initial master, where you're just introducing yourself and perhaps your counsel to the judge can make that determination without any evidence.
Well, the judge has to give you 10 days notice that that's what he or she intends to do. So I imagine it wouldn't happen at a master, but you can say that you're going to apply for asylum, and then the judge can say, fine, I want your application filed by such and such a date. And then you file the application, and then the judge can make a decision saying, I'm denying your application just on the papers because there's not enough evidence. And in addition to the problem I just talked about with that, a huge problem there is that, asylum cases are incredibly fact specific and fact intensive. And we have all seen many, many asylum cases that when you look at them on paper, they don't seem approvable, but when the person testifies and speaks in court and explains everything that has happened and the basis for their fear of what would happen in the future, the case changes. In the same way as you can have cases that are incredibly well presented on paper, and then when the person testifies, the case falls apart and you realize, and it turns out that there really is nothing there. So the essence of all asylum cases is the testimony of the applicant. That's the most important thing. And so when you have to allow judges to deny asylum cases without the person being heard, I mean, I think that it flies in the face of the Immigration Nationality Act and is precluded by it. And there's numerous Circuit Court of Appeals decision talking about the importance of people being allowed a hearing at which they can explain what their case is about. And this would do away with that. And really, and also it would make proceedings much lengthier, because of course, every single person to whom this happens is going to take an appeal. And then they're going to argue on appeal that the judge shouldn't have done it and explain why, and then submit additional evidence. And then the Board of Immigration Appeals may end up sending all those cases back to immigration judges for new hearings, or else there'll be appeals to the Court of Appeals, which will be sending the cases back to the immigration judges for hearings with testimony. So it's really not going to be efficient.
Not at all. What you just mentioned earlier, as far as the case falling apart or not, I mean, many asylum applicants have PTSD. They've been subject to rape. They've seen murders in front of their eyes, and it's not something that they are able to just talk about freely. I mean, it takes sometimes a long period of mental health care for them to just be able to face their past. And that's what that's why the testimony is so powerful in court, because it's not like they're changing their story. They're just able to
articulate
say something
better in person.
Better once they've had treatment.
Yeah.
Again, that's terrible. What about the frivolous nature of asylum?
So the Immigration Act has very strict rules about filing a frivolous asylum application, and a frivolous asylum application has always been defined really as one where it's fabricated, right? So that's kind of what frivolous means in this context. And so if you basically fabricate the basis for your asylum claim, then you are not eligible for asylum or for any other immigration benefits ever for the rest of your life, right? So it has very, very, very draconian consequences. It's like a lifetime bar on immigration benefits, or being able to get any immigration status. And so what this does, it expands the definition of frivolousness way beyond what it has ever been and what it has ever been intended to be. And so a frivolous case would be one that is, one example they cite is a case that is foreclosed by current immigration law. So that means that you cannot argue that even though the current definition of asylum doesn't include your client, that it should. So you can't really argue for a good faith extension to the current immigration law without running a risk of your application found to be frivolous and resulting in a lifetime bar. And of course, that has big implications for attorneys as well as for applicants. It also says that a case can be frivolous if you file it for an improper purpose. So many times people will file for asylum, even if they don't have terribly strong asylum cases, because they may be eligible for, let's say, relief under the Torture Convention, or they may be eligible for cancellation of removal in addition to asylum. And so this allows people to say, no, that you filed an asylum application, and yet when you ultimately ended up pursuing a different type of immigration relief, and therefore we think your application was frivolous and you're barred forever from any other type of immigration benefit. And so this is, it's very important, I think, in the context of asylum cases, because number one, as I said earlier, a lot of people file for asylum on their own. And a lot of people are assisted by people who are not attorneys. And there's really nothing nefarious about that. I mean, you have people whose family members will help them fill out asylum applications. You will have neighborhood people who have traditionally kind of provided assistance to communities who help them fill it out. It may not be the best idea, but it doesn't necessarily have to be part of some nefarious scheme to rip people off either. It's just the way that communities live and the way communities have developed. And this would encourage adjudicators to make all those people ineligible for any immigration benefits ever again in the future, simply because they misunderstood the nature of the application form, or they misunderstood questions on it, or whatever.
Doesn't it also prevent the development and progression of the law? Because new law is made just by litigating new issues. So if you don't allow new issues to be discussed in the court of law, you're essentially making the asylum process just a dead procedure that it's not allowed to grow.
Yeah, I mean, you don't, I mean, it kind of precludes any change in the law, because you can't argue for a change in the law without running the risk of being found frivolous.
Right, and perhaps getting disbarred.
Yeah.
For the attorney.
Yes, yeah. No, I mean, it's horrendous.
Wow. So in your comments that you submitted, I mean, you know, highly technical stuff. One thing that stuck in my head, because I've dealt with it a lot of I think many of us have dealt with it a lot of times, the internal relocation. How's the new proposed rules going to affect the that little
so
concept?
Internal relocation is very interesting, actually. And internal relocation says, the internal relocation rule says that if you can safely relocate, if it's reasonable for you to relocate within the country, right, then you're not eligible for asylum in the US if you can relocate, if it's reasonable for you to relocate to another part of the country and you can do so safely. And then you get into, there's a very technical burden shifting procedure. And so if you have been if you've been persecuted in the past, or if you fear persecution in the future by government actors or state actors, then there is a presumption that you cannot relocate safely within the country, right? And then if your claim of persecution is based on a fear of harm by non-state actors, then you are required to show under current law that that internal relocation is not reasonable. And what constitutes reasonable includes a whole variety of different factors, and not simply persecution. And that's in order to make sure that the US is in compliance with the terms of the Refugee Treaty and the UNHCR handbook on the Refugee Treaty. So let's say that you live in one part of one country, and you are being persecuted there by police officers and also by family members, right? Let's say that you are a woman in a relationship, and you have a long history of domestic violence, and you repeatedly report your husband's domestic violence to the police, and the police then go back and they tell your husband what it is that you have reported to them and that you're trying to have the husband arrested. And so then the police become the persecutors along with the husband, right? And so then under the current law, it would not be, you wouldn't be expected to leave and go to live in another part of the country. Under this new law, you would be expected to leave and go and live in another part of the country. Under the current law, what would be reasonable would be, let's say there is a part of the country that exists like thousands of miles away or hundreds and hundreds of miles away. But if you can show that you have no relatives there, no family there, no friends there, you've never been there, they speak a different dialect to you, you wouldn't be able to find a job there, you wouldn't be able to find employment. It's entirely possible your husband would eventually find you there and locate you, that you would end up living there and not being able to leave that small part of the country and travel again throughout the rest of it. All of those things then would make internal relocation unreasonable. Under the proposed law, the only thing what you would have to show is that you would definitely be subject to persecution in that new part of the country. And that is an impossible burden for most asylum applicants to satisfy.
I would say for, pretty much all of them,
Yeah.
I can imagine, I think the proposed rules make an assumption that other countries have the same set of circumstances as the US or the West, and they don't. In many countries, for example, women aren't even as equal as men. Women don't even have the right to travel outside their countries. Women don't enjoy the same benefits as men. So, I mean, there is no possibility for them to relocate.
Right, but also what in terms of the internal relocation. So what if in the example I just talked about, the woman in question has extensive family in the US. It's not reasonable that because she's been persecuted by her husband, that she should then be banished to go and live in some forlorn, isolated part of her own country where she knows nobody, has no contact with anybody, and will end up being destitute, whereas in fact, she has extensive family in the US. She has a support system here. She has people who will support her and who can take care of her. And she will, assuming she's granted asylum, she will be able to move freely within the country in a way that she would not in her own country.
Right. Wow, mind-boggling. So the firm resettlement, Paul, just a little bit on that. So right now, if somebody is found to be firmly resettled in another country, they're prevented from qualifying. Basically, they don't qualify for asylum. So the proposed rules, what do they change? What do they add?
So under the current rule, essentially, I mean, this is oversimplifying a little bit, but under the current rule, essentially, you have to be living in a country that gives you an offer of permanent residence, right, in order to be firmly resettled there. So if you leave your country, you go live in another country, and then you're there, and the country extends an offer of permanent residence to you, or you could have applied and be granted permanent residence there, but you elect not to, and instead you come to the US and apply for asylum, then you're not eligible for asylum here. So the new rule drastically changes that and says that you're firmly resettled if you spend more than 14 days in another country on your way to the US and could have applied for indefinitely renewable non-immigrant status there, or if you've been there for more than a year and you, regardless of whether or not you had any offer of permanent residence in the country or not, even if you would have faced persecution or torture in that country. And very, very few asylum applicants come directly to the US from their home countries. I mean, some do, but for the most part, people fleeing persecution travel on a somewhat circuitous route to get to the US. And this would require this would make most of those people ineligible, because it's going to require them to prove what the immigration laws are in every country that they've traveled through, whether or not they would have been eligible, not just for permanent residence, but for non-permanent residence. In other words, if they could have applied for some sort of tourist status there and renewed it, or some sort of temporary work visa there and renewed it, regardless of the circumstances under which they would have lived there. And it's going to be, it's a burden that would be virtually impossible for most people to reach or to satisfy. And really, this is going to just be pretty much for people who have traveled to a third country on their way to the US. This is just going to make all of those people ineligible for asylum in the US. And again, you have to go back and look at, the origins of the Refugee Convention, and it was post World War II. You look at all the people to whom we now look at as sort of like the bona fide refugees, which would have been like Jewish people fleeing Europe before and during the Second World War. Almost all of whom would have traveled through at least one other country after leaving their country of origin prior to finding a country that was able to offer them refuge. And none of those people would be eligible for refugees, for asylum status under this new act. Or this
I mean, it's heartbreaking. We can't lose sight of the fact that people that aim to come to the US, it's not like they come to go to Disneyland or visit the Rockefeller Center. They literally are coming here to save their lives.
Yes.
And they've chosen the United States because of US's history of being generous with refugees and, at least since World War II. Mm-hmm. And in general, us being a nation of immigrants. So it really goes counter towards all of those ideals that America stands for.
Yeah. No, it is. It is, and really that any kind of country that claims to have a refugee policy and obligations under international treaties that it has incorporated into its own law, as the US has done, but also I think one of the most fundamental, one of the biggest problems, there are many big problems with it, but one of the problems with this regulation is that, in enacting the Immigration and Nationality Act, so Congress enacted the immigration law, including the eligibility procedures for people applying for asylum, right? And all of the substantive law for people who are applying for asylum. And that has been refined over decades of decisions by the Board of Immigration Appeals, by all of the circuit courts of appeals, and by the US Supreme Court. And so here you have these regulations being proposed by people who have been in government generally a very, very short time. And they're proposing to rewrite all of the eligibility requirements for asylum. Not the manner in which asylum law is implemented, but the actual substantive law itself. And that's not what a regulation is supposed to do. A regulation is supposed to implement the acts of Congress. It's not supposed to rewrite an act of Congress. It's not supposed to rewrite the law. It's supposed to, provide the mechanism by which it's implemented.
So you just answered my last question. So I'll have another last question for you. So we're on July 16th today. We're we're just a few months away from the elections in the US. If there is a turnover in the government, both Congress and the presidency, if that were to happen, I guess, can this be stopped or can this be reversed, or can Congress have a say in this?
So Congress, I don't think, so Congress could have a say in it, in that they could pass another act that says that, basically overrides these regulations. But I think what is more likely to happen is, if we do have a change in government, that I would hope and I would assume that the regulation will be withdrawn.
How long is it going to take for these regulations to be implemented as is? Well,
that's a good question. So under normal circumstances, a regulation this weighty and detailed, the proposed regulation is like 160 pages long. And so when that's opened up for public comment, the public comment period would typically be 60 days. And then it could take the government, so then the government has to read all of the comments. And then when it publishes the final rule, it has to take all of the submitted comments into account. And so if it were to be approaching this sensibly, or not sensibly, but if it were to approaching this the way agencies have traditionally approached, rulemaking on such a grand scale, it could take up to a year for this new regulation to be put in place. Rather than give 60 days to submit comments, the agency has only allowed 30 days. And so I would expect that they will read through all of these comments incredibly quickly, will probably not pay attention to them properly, will probably not do it the way that they are required to do, and will put this new regulation into place very, very quickly. And then we will just have to see what happens with the election in November, and see if basically what is basically like a war against immigrants, can be stopped.
that's where we are.
Yes.
Yeah, Paul, thank you so much for your time this morning and the
Thank
detailed
you.
analysis. Oh, absolutely. I'm learning as, you know, I'm talking to you and I'm reading your comments. I really appreciate it. And we'll see you next time.
Yes, you will. Bye-bye.
Have a great day.
You too.
Bye.